A very warm welcome to this, the 10th lesson in our series on the law of evidence. In today's lesson, we will talk about the meaning of evidence as to what evidence means in the context of the Indian Evidence Act, and we will also discuss some of the types of evidence. Let's get into the lesson. Let us say you went to a mall, so you parked your car in the parking lot. You went, watched your movie and came back, and there you find in the parking lot that somebody is maybe sitting on your car or standing beside it. Now you tell him to get aside, and he says, why should I get aside? You say, this is because the car is mine. And then he's like, well, I don't believe it. What proof do you have? So he asks you, what proof do you have? And then you perhaps show him some photograph that shows that you are the owner of this car, or maybe you show him the RC or whatever. Now, if he had asked the question differently, what evidence do you have that this car is yours? Then again you would have done the same thing. You would have shown him the photograph, or you would have shown him the RC. Does that mean that proof is the same as evidence? Because when you were asked what proof do you have, you showed the same thing. When you were asked what evidence do you have, again you said the same thing. So does that mean that proof is equal to evidence? Take a moment to think about it. So as regards proof and evidence, they are often used synonymously, right? So in fact, you'd find, especially in the common parlance in our day-to-day conversation, proof and evidence are used synonymously and interchangeably. However, that is not an accurate way to use them, especially in the context of the law of evidence and the Indian law of evidence, right? Let me tell you the main difference between the two. Proof is the consequence of evidence, which means you adduce evidence, you show evidence, and thereafter you reach to the consequence or the conclusion of proof. In other words, proof is the effect of the production of evidence. You show evidence and then proof happens, right? So evidence is the route or the means to achieve the end of proof. So getting back to our example, if we were to understand this example in the proper context of the law of evidence, let us say somebody is standing by your car and this person knows the law of evidence. So now what he asks is, what evidence do you have? You say, well, I have the papers, okay, and you show him the papers. Now, as a result of showing these papers, the consequence is that you have succeeded in proving that the car is yours. So now you have got the proof that the car is mine. So you showed the evidence, the consequence is that the car is yours. So you must remember that the effect is proof, right? And how is this incorporated into the Indian Evidence Act? Very simple. You always start off with a fact, and the fact obviously is a disputed fact. You see, the need for evidence arises only when there's a dispute. If he said, this car is mine, a person says, okay, sorry, bhai sahab, I'll get aside. And he gets aside. Is there any dispute? No. He asks him to get aside, the car is mine. He says, how do I believe you? That's a dispute. It's a disputed fact. So when you start off with a disputed fact, what do? You adduce evidence, right? Now, once you adduce evidence, you can have a conclusion regarding the truth or the falsehood of the fact, which is basically the proof of the fact, and that can have three alternatives. The first, second and third alternatives, right? What can that be? Either the fact is proved, or the fact is disproved, or the fact is not proved, right? I've discussed this in an earlier video, right? So what we understand is that these three things, this is what proof is, right? Proof is the conclusion, proof is the effect of the production of evidence. So now we understand what proof and evidence mean. Now let's look at evidence in the context of the Act a little more closely. So evidence, as I discussed, is a means. It's not the result. It's the means. What kind of means? It is the legal means, exclusive of a mere argument, which means you're also showing something. An argument is basically a structure of words that you create in order to prove something, right? So evidence is more than simply an argument. It is something which is a means, of course, but it goes beyond simply an argument. There is more to it than just an argument. So there is something you're showing, maybe papers, maybe a witness or whatever. We'll talk about that in a bit. But it is the legal means, exclusive of a mere argument, which tend to prove or disprove any matter of fact, which lies in dispute before the court. Very simple. There's a disputed fact that has to be proved or disproved. For that, you use some means. Those means are called the evidence. Simple. Let's look at another definition. Evidence, the means from which an inference may be drawn logically as to the existence or non-existence of a fact. So what is the conclusion? The conclusion is the inference. Does this fact exist or does it not exist? How do you do that? By the means of an evidence. So I hope you understand this point, that evidence is the means, proof is the consequence or the effect or the end, right? So again, let us look at one more definition of this. Evidence may be defined as any material which tends to persuade the court of the truth or probability of some fact asserted before it. If you remember, truth is something that we don't always talk of, so it's always good to say truth or probability. When we believe that something exists, that means that a fact is proved, it means the court considers it highly probable, right? So when there's a fact and you have to persuade the court to believe or not believe, like you want the court to believe that okay, this car is mine, or the other person wants the court to believe that the car is not mine, right? For that you use evidence, okay? Now, what is the meaning of material? I want you to understand this thing in the context of the definition of fact that we had studied. What is material? Is material a thing? Right? If you remember, when we saw the definition of fact in section 3, a fact is anything, state of things or relation of things capable of being perceived by the senses. If you remember, so let me just shorten it for you. Anything which can be perceived by the senses is a fact. Does that mean a material? This word that you see here, material. This material, is it also a fact? Well, going by the definition, it appears that a material is a fact. So in order to answer this question, whether material is a fact, like the material might be the paper or it might be some photograph, all of these things are material, right? So is the material a fact? I'd have to say yes. The next question that follows obviously is, if evidence is a material and the material is a fact, is evidence a fact? Well, going by this logic, I'd have to say yes. Now, what kind of fact is it? It's important for you to understand that evidence is a fact, true, but it is the kind of fact, it's a type of fact which you can see in comparison to the definition here. You can juxtapose both of these and see them. And evidence, of course, is a fact as well. So like you know that fact is a very large set, right? Evidence is something within that, because evidence is also a fact, right? So you're right when you say that evidence is a fact. But what kind of fact is it? Well, evidence is the kind of fact which tends to persuade. So it's exactly the same thing here. I have repeated that for you. So the kind of fact that persuades the court to believe the existence or non-existence of another fact is an evidence, right? So you understand the concept of evidence and what evidence is. We've not yet seen the definition of evidence in the Act, but we've seen several definitions that have been given by the courts, and we've also seen as to how it is different from proof. Now let's go ahead and see how it is defined in the Act. Alright, so section 3 is the interpretation clause of our Indian Evidence Act, and it contains various definitions. It also includes the definition of evidence. At this point, take a moment, pause the video and look at the definition of evidence. I've kind of organized it for it to be more clearly visible to you. Take a moment, pause the video and read it. Okay, so what do we have here? We see that evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to the matters of fact under inquiry. Okay, so what does that mean? It's basically the statements which are made by the witnesses before the court. It goes on to say that such statements are called oral evidence. I want you to pay attention to this. It says that such statements are called oral evidence, right? Now let's go ahead and read the second part of it. It says that all documents, okay, all documents including electronic records produced for the inspection of the court. So evidence means it includes, first, all statements made by witnesses, second, all documents that have been produced for the inspection of the court. So all documents including electronic records which have been produced for the inspection of the court. Now look at this. Such documents are called documentary evidence, right? So if you look at the first part and the second part, then you come to the conclusion that the Indian Evidence Act contemplates two types of evidence. It's important for us to also know that electronic records are to be treated as documentary evidence. That is something that we get from the second subpart, right? Subpart 2. So now we understand that there are two types of evidence. What are the two types? The first type is oral. What is oral? Oral is the statement that has been made by the witness before the court. Okay. What is documentary? The second type? Well, the documents that have been placed before the court for its inspection are documentary evidence. So we understand two types. But when you see the topic of types of evidence and you open a book or you look at any other source, you will find numerous types of evidence: primary, secondary, direct, indirect, and all of these types, right? You've definitely heard of several of these and many more. I will just briefly touch upon what these types mean and how you should understand these, and then of course you can go ahead and read them in detail. Also, in my later videos, I have discussed these in greater detail individually. What I need you to understand now is that regardless of what the type of evidence is, what it is called, every evidence has to be either classified as oral or documentary according to the Indian Evidence Act. In other words, when we talk of the types of evidence, then in the context of the Indian Evidence Act, there are only two types of evidence: oral and documentary. However, there are several other ways in which we can categorize them, and each one of those categories will also either fall into oral or documentary. So now I will try to illustrate this point to you, that we have several types of evidence, but each one of them would either be oral or documentary. Also, I'll briefly explain these types to you so that you can now go ahead and understand them by your own self. So when we talk of the types of evidence, let's start with this thing called primary and secondary, right? So when we talk of primary and secondary evidence, these are basically types of documentary evidence, okay? Now what is primary evidence? Primary evidence is generally the evidence which is like the original document, right? So when the original document is produced, it is the primary document. However, if you are required to get a copy of the original in whatever form, whether as a photocopy or whatever, then broadly that is what we understand as secondary evidence. So you understand now that primary evidence and secondary evidence are two types of documentary evidence. So I will ultimately show you that everything is either oral or documentary. Moving ahead, we have direct and indirect. You see, direct and indirect can be used in a couple of ways, but you can think of it like this for the time being, that direct and indirect are types of oral evidence, okay? So let us say somebody has seen something and he is a direct witness of it. What that means is that somebody has seen an occurrence, he goes ahead and then testifies before the court about what he has seen. That is direct oral evidence. On the other hand, what could happen is that somebody sees something and then he tells another person, and now this new person goes to the court to speak about what his friend had seen. Here it is indirect evidence, okay? Now, indirect has another meaning as well. So in the first meaning that I just used right now was indirect in the sense of hearsay, right? Where somebody saw it, he tells a third person, and then this third person goes and deposes before the court. This is hearsay. Another way in which direct and indirect is used in the meaning of circumstantial evidence. I'll just talk about that in a bit. In case you're not understanding what's happening right now, don't worry. I'm just introducing these facts to you and these concepts to you. Don't worry. We've already seen the categories of oral and documentary, so I'll not talk about them any further. These are the statutory categories. So of course we know what oral and what documentary is. Moving ahead, I was talking about circumstantial evidence. Now, in terms of circumstantial, you can think of circumstantial as being another kind of indirect evidence. Let me tell you how. Let us say there was a person who was found dead in a certain room. Okay, so this room was of course locked and there was a door, and now there's a person standing on let's say the passage outside this door. Now this person sees one person running away, right? From this door, he sees him running away. Now he goes into the room and then he finds that a person is lying dead. Now, has he seen this person killing this person? No, he hasn't. So can it be direct evidence if he says that yes, I saw this person killing him? It's not direct, right? Because he's not seen the actual incident happening. Instead, what he sees is a circumstance. What does he see? He sees, okay, a person is dead and a person was running away and he was looking scared, running away fast from that room. So what he has is what is understood as circumstantial evidence, right? So circumstantial is also a kind of indirect evidence. So I hope you understand the difference. When you see the actual incident happening, well, that is direct because you saw the actual occurrence. Now in this case, you are seeing a surrounding circumstance. You're not seeing the actual incident. So when you see the surrounding circumstances, that is circumstantial evidence. Moving ahead, let's look at the next type. You must have heard of these phrases as well: corroborative evidence and substantive evidence. Well, substantive evidence is the kind of evidence that can stand by itself to prove a certain point, right? Which means substantive evidence is a strong type of evidence that can be used by itself in order for a fact to be proved or disproved, right? That is substantive evidence. On the other hand, corroborative evidence is the kind of evidence that is not really evidence by itself, but it can be used to strengthen or to support an existing piece of evidence. So we understand it like this, that substantive evidence is something which is good evidence even independently, even by itself, right? Whereas corroborative evidence is a kind of supporting evidence. Corroboration is the act of supporting, so you can call it corroborative evidence if you're talking about the type of evidence, and corroboration is the process of supporting, right? Do not use the word collaboration. A lot of students call this collaborative evidence. Please do not do that. It is corroboration and not collaboration, okay? Then you've also heard of electronic evidence. Well, we just seen that electronic evidence is a kind of documentary evidence. Actually, it's an independent kind of evidence, but every evidence falls within either oral or documentary, and we know what electronic evidence is. If there's a WhatsApp chat, if there's a photograph, if there's an email, a video recording, a CCTV recording, all of this is electronic evidence, right? And well, the last example that we've chosen here is forensic evidence. Now, forensic evidence, if it is given by a witness, right, if it's given by an expert doctor, he comes and now deposes before the court, the forensic evidence becomes oral because it's given by a witness. Likewise, the forensic evidence, which is basically medical and law, right? So the interface of law and medicine is what is the discipline of forensics. So forensic evidence is medical evidence given in law. So we understand that if a witness comes and says it, it is oral. However, if the forensic report comes in the form of a document that is placed before the court, then forensic evidence can be documentary as well. So as you see, whether it is substantive or corroborative, if a witness now comes and gives a piece of evidence that can stand independently, it is oral. If there's a document, it can be written. Similarly, corroborative evidence can be either oral or documentary, depending on whether it comes through a witness or whether it comes through a document. Similarly, forensic evidence, it can be either oral or documentary. So you get the idea. We have various types of evidence, yet each of these types is ultimately either oral or documentary, because it comes to the court either in the form of a witness or it comes in the form of a document, right? So I hope you've understood what the meaning of evidence is and you've understood the various types of evidence. Thank you so much for your patience. Good day.